have to have a line in the sand that we mean. And that's mine. And the next thing I'm going to ask you is, what's yours? Do you have one? If you don't, think about it. Because we may need those lines before this is over. We're going to court. This is the boring part, everybody. This is the part where nothing happens for long stretches of time. This is the part where the summer soldier and the sunshine patriot shrinks from the service of his country. There are no big battles being fought. We're in court. It's tedious. God, it's boring. Geez, I read 3 cases today, and I got to tell you, I would rather eat lead than read another one of those. But you got to read them and you got to understand them, because if you don't, you won't understand the questions, and we have to understand the questions or we're going to lose. So in the court proceeding right now, we've sued the state. They appointed an attorney. He brought this really weak motion to dismiss, and he said two wrongs make a right, where yes, we don't have representation in California, and I'm paraphrasing. This was about 4 pages long. But since everybody's screwed equally, there's nothing the court can do about it. That's the two. I got to the end of that, and I thought that's the laziest argument I've ever heard in my life. But it's been used before, believe me. So our attorneys are working nonstop, and they have come up with some things out of the 19th Amendment, the 26th Amendment, the 14th Amendment, several Supreme Court cases, not the least of which is Citizens United v. the House of Representatives, where it says you have a material interest to maintain the value of your vote. What is the value of your vote? Well, so it's funny, that brings up another word. It's worth less than it was before. Or should I speed that up? It's worthless. More so than it was before. Worth less, worthless. Those 2 words obviously have the same root. Well, in 1850, when the founders of this state declared that they were grateful to Almighty God for our freedom, that to perpetuate and secure its blessings, they established this Constitution. They laid out a government where every 6,000 people had a state senator and every 2,500 had an assemblyman. Somewhere along the line, the power got good to them. We think it's because they wanted to deny the Chinese political power. They capped the legislature at 40 senators and 80 assemblymen in 1862. And it's remained the same ever since. We now have a situation where we have 1 million people for a state senator and 500,000 for an assembly person. And that is the worst ratio in the United States, 400% worse than Texas, which is state number 49. So they have like 200,000 per senator and 100,000 per assembly person. We're at 1,500,000. So what's our argument in court? Is it that we want the state of Jefferson? It can't be. I wish it was. But it can't be, because there's no judicial way to split a state that's constitutional, legal, ethical, and moral. And here's our problem. We pledge our lives, our fortune, and our sacred honor to this cause. So if nothing else, we have to have integrity. We have to be more honorable than the other side. We have to take the high road because we're Christians, because we're citizens, because we care, and because we believe in the document that established this government, because we believe that the people who wrote that meant what they said. That's an issue. By God, it's easier just to start, wailing on them, isn't it? But we can't do it that way. So in court, we have to prove certain things. And here's the main argument we want to prove. 40 and 80 ain't enough. That's it. It's pretty simple. If we can get them off the dime, if we can get them to admit that 40 and 80 is not enough representation for 40 million people, now we have a Sherman tank we can drive through that hole. Once they stop saying, in fact, they have never yet said in any of their filings, oh, no, we have plenty of representation in California. They're not saying that. There's another cool case, and I forget the name of it, but I just read it today, and I already can't remember it. That's how enamored I am of that stuff. Excuse me. But there's another cool case that says that if a defendant fails to argue in the pleading the initial cause of the suit, he loses the right to do that in an appellate basis. So if the state does not argue, we're saying we don't have enough representation. If the state does not argue, oh yes we do, they will lose the right at some point to make that argument. I mean, God, these people are stupid. I don't want, I don't want to seem, I don't want to seem overconfident here, but that would be the first argument I would make if I were them. If I was saying you don't have enough representation, the other side, I'd say, well, sure we do. And here's the proof. And here's all the good stuff we've done for you. We're the 6th largest economy. Gosh, you can't have any guns, but you can have all the, all the taxes, all the marijuana and taxes you want. You could make that argument. They're not trying yet. They won't stay stupid forever, but we need to stay a step ahead of them. So we're in the process now where the state, we have filed our case. The state has filed their motion to dismiss. That's a normal procedure. We say, you guys are wrong. They say, no, we're not because of this, dismiss, Your Honor. And they're saying this is a political question which the court can't settle. And then they also have the 2 wrongs make a right. But our argument to that is, yeah, it is a political question, but it is a political question the court messed up to begin with. Because when we go back to Reynolds versus Sims, Baker, and Gray versus Sanders, the dissenting justices in those cases all said, this is a state political issue and the federal court has no business meddling in state election affairs. Now, had the court listened to itself, we wouldn't be having this conversation because the state could literally do anything it wants to us. But the federal government made a mess of this. So our defense to that is we're going to say to the feds, to the federal government, yes, it is a political question, and had you stayed out of it to begin with, we wouldn't be here. But because you screwed this up, we're in court, and we're going to make you unscrew it. And we have Supreme Court justices that we believe in Clarence Thomas and Neil Gorsuch and the other couple conservatives that we think will do it. So now on August 25th at 10 a.m., at the federal courthouse in Sacramento will be our first hearing. I would dearly love to pack that room. Somehow I have to get off work. I'm willing to get fired over this. I'm going to try to be in that courtroom. If there's a way to humanly do it, I'll be there. I would love to see that courtroom packed. It will send a message to Judge Mueller. It is August the 25th at 10 a.m. in the federal courthouse in Sacramento. I don't know what courtroom, but someone there will certainly know when we get there. We're hoping for courtroom number 1, which is the big giant one. And we would love to fill her up. Imagine that. And bring your gear, show up, and let's show the federal court that we will not go quietly into the night, that we are prepared to give our last full measure for the cause of liberty.